Welcome to Confidentiality and Privileged Communication for Rural Sexual Violence Advocates. Thank you everyone for coming today. My name is Victoria Riekers. I use she, her pronouns, and I am one of the sexual violence response coordinators at the Arizona Coalition to End Sexual and Domestic Violence. And so before we get started, I just want to go over a few housekeeping items. So today we have interpretation available in Spanish. Hay interpretación en español hoy. So if you would like to hear interpretation in Spanish, you will just choose the Spanish channel at the bottom of your screen to be able to hear the interpreter. Por favor, elija el canal español para escuchar en español. And then to listen in English, you can listen on the default setting. And then sometimes there can be audio issues when we have interpretation. So if you cannot hear me, please choose the English channel, and that may help your audio issues. So I'm typing that in the chat as well. Okay. So I just want to do a sound check because I've gotten some comments that folks can't hear. So can you please type in the chat if you can hear me or if you cannot hear me? Awesome. So I'm getting back that a lot of people can hear me. And so Sam, if you want to help Cassandra, I think she might be the only one who can't hear right now. But I'm going to move on. So we also, if you can see, we have the ASL interpreters as well. So if you want ASL interpretation, but you cannot see the video, you can put the video or the Zoom in split screen mode, and then you should be able to see them. And then please ask any questions that you have in the Q&A instead of in the chat. So we're going to be using the chat to participate. And if you ask a question in the chat, just because of all the participation, I might miss the chat. And so please put all of your questions in the Q&A. That way I can see them really easily. Zoom bombing won't be tolerated, so we know that's always a risk with Zoom. And so if we need to, we will shut off the chat and then we won't be able to have an interactive webinar today, but I don't expect that to happen because I think it hasn't happened yet for us, so knock on wood, it won't happen today. We will also have an evaluation at the end, so please complete that. That helps us with our grant purposes. And I also really want to know how to improve my trainings. So I really appreciate any and all feedback. And then if you would like a certificate for this training, I will have instructions on how to get a certificate at the end. And then one last thing that I want to mention is if you need to get a hold of Samurai privately, please just switch your chat to the private mode to chat the just Samurai. If you chat the panelists in private mode, all of the interpreters will also be able to see that. So if what you want to say, you want to be private between like Sam or I, please make sure you're just selecting Sam or myself. And then I will see it eventually, but since I'm presenting, I may not be able to respond right away if you private chat me. So if you really need to get a hold of us, I suggest you private chat Sam. I think that's everything for the housekeeping. So we will go ahead and get started. So just a quick disclaimer, I am not a lawyer. I cannot give you legal advice, and I am not giving you legal advice today. So just want to put that out there, that this is not legal advice at all. We are going to go over what the laws say about privileged communication and confidentiality, as well as some other things related to confidentiality, but I am not a lawyer, and so I cannot give legal advice. All right. So what is privilege, confidentiality, and privacy, right? I feel like we throw these words around a lot, and they actually all have different meanings. And so I want to kind of briefly go through what these words are, since sometimes we'll use them interchangeably, but I want to avoid using them interchangeably for today. So privacy in general is going to be a personal choice whether or not to share information, right? So I have the right to privacy and I can share as much or little about myself as I want. So, right, so I could, let's say I break my arm and then I want to post about it on Facebook. That's my right, right? But my doctor can't go on her Facebook and post about my broken arm, right? That's not okay. And then confidentiality is the responsibility to protect someone's choice about sharing their information, right? And so we have laws about confidentiality for advocates, and this is really about protecting that choice. Then we also have privilege, which is the legal rule protecting private information, right? So privilege is how it works, right, in courtrooms and also sharing information among people with different roles and different jobs in our field, right? So the two that we're really focusing on today are confidentiality and privilege, right? Because we have different federal laws that govern confidentiality and privilege, and we also have Arizona laws that govern that. All right, so what are these federal laws that govern the victim service providers' confidentiality rules? So I'm sure this will come as no surprise to any of you, but we're going to be talking about the Violence Against Women Act, the Family Violence Protection and Services Act, and the Victims of Crime Act. Right, so all of these are laws that have grants kind of attached to them. And if you receive grant funding for any of these three, which I'm sure everyone on the call today does, then you have to follow their confidentiality rules. There may be other federal laws that apply to you. So for example, if you are an advocate and you work at a health clinic, HIPAA may also apply to you. I'm not going to be going into HIPAA today, but I know you will be receiving training on that from your clinic. But in general, when there are multiple different federal laws applying to you, you're going to want to follow the confidentiality protections of whichever law has the strictest protections. Typically, VAWA, the Violence Against Women Act, is considered to have the strictest confidentiality protections. They're very, very similar across VAWA, FIPSA, and VOCA, but VAWA is typically considered the strictest. And VAWA, and all three are stricter than HIPAA in most cases. All right, so like I said, VAWA, FIPSA, and VOCA will apply to you if you receive funding from those laws, right? They protect the confidentiality and privacy of anyone receiving services from your program. And the confidentiality protections are very similar between the three laws. So what are they? So first of all, you cannot disclose personal identifying information or any information related to the services. All client information cannot be shared without informed consent and time-bound consent, right? So we'll have releases of information to share any kind of information about clients. And we'll talk a little bit more about that as we go. You also cannot force anyone to release their personal identifying information as a condition of services, right? So no one has to tell you anything about them to receive services from you. And you cannot share personally identifying information, even if your goal is to comply with grant reporting, evaluation, or data collection. So this would be, in addition, like if you have grants that are completely unrelated to VAWA, FIPSA, and VOCA, but you receive VAWA and FIPSA VOCA grants, if that other grant is asking for reporting information that's in violation of VAWA, FIPSA, or VOCA, you cannot report that information. It's going to be rare that that's going to happen because those grants should also be aware of these kinds of confidentiality rules, but it's something to keep in mind just in case. So what is personally identifying information? So really this is any kind of information that you can identify someone from, right? And so this is what the VAWA statute says about personally identifying information. But in the chat, I would like you to list out different types of personally identifying information. So what are different types of personally identifying information? I'm seeing ethnicity, name, date of birth, social security number, age, voting record, address, phone number, social security number. Yeah, absolutely. What if you are in a really small community? What are some things that might count as personally identifying information? Gender identity, police records, religion, the family they're married into, place of work, household composition, right? Right, like if someone's a twin and you're in a really small town and they have like one set of twins, um, you're gonna know who that person is, right? Their other family members' names, the date of the incident, absolutely. The community they're from, right? So under VAWA, here are what they list out as personally identifying information. So you got all of them, right? First and last name, their physical address or their home, contact information. So I know a number of you listed their telephone, their address, so even their email, their internet protocol address, also known as their IP address, or a fax number. Social security number, many of you mentioned. A few that I don't think I saw was driver's license number, passport number, student identification number, anything like that. I think someone mentioned something related to the military, so like your military identification would count as well. And then any other information that would identify that individual, right? So someone mentioned ethnicity, and that's why I also asked if you are from a small town area, like what are some of those things? Because it's kind of an open bullet, right? It's going to really depend on your community and what your community looks like, right? So if you are from a community that has a specific ethnic group community as a part of it, they may be more easily identified, right, based on their ethnic group. Like I think I mentioned the twins example, right? And many of you mentioned different family members or family composition. So yeah, that's great. So VOCA, FIPSA, and VAWA does have some information that you are allowed to share. So you're allowed to share non-personally identifying information in the aggregate, right? So a lot of the like grant reporting is going to be like this. So it's important to remember that it says in the aggregate, not at the individual level, so multiple types of data at once. You're allowed to share court-generated or law enforcement-generated information that's for the purposes of protection order enforcement. And so you're going to know that it is court-generated or law enforcement-generated because that's where it's going to come from. And you're also allowed to share law enforcement and prosecution generated information for the purposes of law enforcement or prosecution, right? So again, that's going to come from law enforcement prosecution. That's not going to originate with your program. Okay, so we also want to talk about releases of information. All of those laws say that you need to have informed consent, time-bound releases of information, and they need to be written. right? This is further enshrined in Arizona law, which we'll get to in a second. But we need to have these releases of information. A few things about them is they cannot be blanket releases, right? So they need to be specific. They need to be releases about a specific agency they can be released to, even a specific person at that agency they can be released to. But they can't be like, I can release your information to anyone who has the goal of helping your case, right? That's too broad. We want it to be specific. It must be signed by the victim to be valid. If it's not signed by the victim, you cannot release information. And then if the victim is minor, it can be a little tricky. So VAWA says that if the victim's a minor and if they can legally consent to services without a parent, then they can legally sign the release of information without a parent. If the victim is a minor and they cannot legally consent without a parent, the parent and the victim must sign the release of information. So that means if the parent wants to release the information, but the survivor does not, you cannot release the information. Both must sign, and vice versa. So if the survivor wants to release the information, but the parent does not, then you cannot release the information. The reason I go over both is because Arizona law is silent on whether or not teens can even consent to services without a parent, right? So it's, I am happy to have conversations with you all offline. If you have questions or concerns about teens accessing your services, but it is, the programs should all have a policy in place about whether or not teens should consent to services, or if they would need a parent to consent to services. And you would need to write this with a lawyer to really develop a good policy, because the law is completely silent on this matter. So it makes it a little confusing for victim service providers as to what minors are allowed to do. But yes, like I said, I'm happy to have a conversation about that offline after the webinar if you are interested. And then VAWA also says that if the victim is a legally incapacitated person under the law, and that they have a court-appointed guardian, the guardian is the one who signs the release of information. So someone asked, what's the definition of legal consent in the case of a minor? Are you talking about the consent to services or consent to sexual activities? So the consent to services, there is no legal definition of whether or not minors can consent to services. Minors can consent to sexual activity when they are 18, so when they are no longer minors. Okay, and then VAWA, FIPSA, and VOCA also have protections when it comes to subpoenas and court-ordered releases of information, right? So in most cases, the survivor needs to consent to the releases of information. However, if it is court-ordered, then it's compelled by statute or the court that you do need to release that information. And there are different things that you need to think about when this happens. So you are required by law to make reasonable attempts to notify the victim if this happens. And then you also do need to take steps to protect the privacy and safety of anyone affected by this release of information. If you do receive subpoenas, there are different things that you can do as well. You want to double check the subpoena that you receive to make sure that it is signed by a judge. If it's not signed by a judge or a judicial officer, then VAWA does not compel you to release that information. So you do not need to comply with a subpoena unless it is signed by a judge or a judicial officer. Right, and if you do receive the subpoena, it's really important that your programs have policies in place for how to respond to subpoenas. And then again, if you do need assistance with that, I recommend reaching out to a lawyer to really write a clear policy regarding that. I also have a handout that I plan to share after the training that has guidance on how programs should respond to subpoenas from the National Network to End Domestic Violence. And then one thing that might happen if you get a subpoena, in some cases the survivor does want you to respond to it, right? So if the survivor wants you to respond to it, you should respond on the survivor's behalf, right? It is their choice whether to respond or not. Okay. Then I see another question in the chat. What conditions would make a minor capable of legal consent in order to sign a release for themselves? So like I mentioned, the Arizona law is silent on that matter. And so it's really up to the programs to develop a policy as to whether or not the minor can consent, right? Because there is no Arizona law that says whether or not a minor can consent to services. And then under VAWA, if a program allows a minor to consent to services, then the minor can consent to sign the release of information for themselves, right? So it's really important for your programs to have really clear policies about whether or not minors can consent to services, whether or not minors can even be served at your program. And this is really going to depend on how much risk your program wants to take on, like how much legal risk, right? And so that's why I really, really encourage you to hire an attorney so the attorney can review all of the different laws out there about minor consent and see if there is anything comparable to sexual violence advocacy so that they can help you determine whether or not it would be a risk to allow minors to consent without a parent, or if it would be better for your organization for minors to consent with a parent. And then depending on how minors can or cannot consent, that will influence how the release of information is handled. Please let me know if that was clear. If not, I can talk to you more offline about that. All right, so now we're going to move to the Arizona specific laws. So Arizona law talks about both criminal and civil cases, and there's two different types of advocate privilege, right? There's on the civil side and the criminal side. So the criminal side is really just about the crime itself and is about the legal punishment of that offense. And in criminal cases, like I'm sure many of you already know, it's the state that prosecutes the crime, right? We have the prosecutors and they're the ones prosecuting the crime, and the victim is considered like a witness. On the civil side, things are a little different. Civil law is going to include really anything that's not that like crime, like the guilty, not guilty of the crime itself, right? So this includes a lot of the work that advocates do. So orders of protection, injunctions against harassment, that's all civil. Immigration issues, that's all civil. Divorce, custody issues, any family law, that's civil. And then civil suits, so like if a survivor sues for damages, that is civil as well. And so we want to make sure that you are protected on both sides. And so we're going to go through what is required of you all to be protected on both the criminal and civil sides. So on the civil side, we have two types of advocates. We have the domestic violence victim advocate and the sexual violence victim advocate. The statutes are pretty much identical, other than that it talks about domestic violence or sexual violence, right? And so under the domestic violence victim advocate, you must be an employee or a volunteer at a domestic violence shelter or service provider for victims of domestic violence. And you must meet the training requirements of this section, right? So the training requirements are attending 30 hours of training in assisting domestic violence victims. So if you aren't sure if you are a domestic violence victim advocate, if you've met the training requirements, one option is to take the 40-hour training, the sharing experience. Sam just talked about it in the chat. If you take that, you will be covered as long as you also work at a domestic violence program. Same goes for the sexual violence advocate. So again, you need to be an employee or volunteer of a sexual assault program or service provider. And you also need to have 30 hours of training assisting sexual assault victims. So again, if you aren't sure if you've received that 30 hours of training, you can attend the 40-hour SVCAT, which is the Sexual Violence Core Advocacy Training. And then you will meet the requirements for being that sexual assault victim advocate. The reason I'm plugging those trainings is because we really do want to make sure that you are protected when it comes to your privilege as an advocate. So those two statutes talk about privileged communication in a civil action. So anything on the civil side of things. So those orders of protection, immigration, family law, anything like that. So the statute says, in a civil action, a sexual violence victim advocate shall not be examined as to any communication made by the sexual violence victim to the sexual violence victim advocate, right? So this means that basically you can't be a witness and your communication, whatever it looks like, cannot be used as evidence in these cases, unless the survivor wants it to be, but that is quite risky if that does happen. Privileged communication does not apply when the victim advocate has a duty to report non-accidental injuries and physical neglect of minors. So any kind of the mandatory reporting requirements you have for child abuse, privileged communication does not apply. You do have to report. And then the other way it doesn't apply is if the victim advocate knows or should have known that the victim was going to perjure themselves, right? So if they were going to lie on the stand or give a perjurous statement, so that they were going to lie in their statement. And it would disprove the existence of sexual assault, right? So that you would also need to report. The only other time it doesn't apply is when there's a civil action that is related to the civil commitment of a sexually violent person, right? So this is going to be like a really, really specific kind of case, and it's related to civil commitment of a very select group of people. So now that's all on the civil side. So the criminal side has a little bit more detail. On the criminal side, there's the crime victim advocate, right? And so a crime victim advocate is a person who is employed or authorized by a public entity or a private entity that receives public funding primarily to provide counseling, treatment, or other supportive assistance to crime victims, right? So if you are a domestic or sexual violence advocate in a program, you are also considered under the law a crime victim advocate. If you're a crime victim advocate, your information is privileged on the criminal side as well. And so in this, all communication between a crime victim advocate and a victim is privileged unless the victim consents in writing for you to disclose that information. This statute also lists out all the things that can count as communication. So any of your records, your notes, any documentation or correspondence, reports or memoranda that contain any opinions, theories, or any other information, that all counts as communication. With a crime victim advocate, this also includes communication made to or in the presence of others, right? So for example, if I am an advocate and someone comes in and is talking to me and they bring their friend as a support person, even though their friend is present, all the communication the survivor tells me, everything the survivor tells me is still privileged. It's not privileged for the friend, right? So the friend does not have that privileged communication, but everything that's told to me in the presence of the friend is still privileged. Communication for a crime victim advocate is not privileged when the crime victim advocate knows the victim will or has given perjured testimony. Right, so again, if they lie on the stand, or if the communication contains exculpatory evidence. So what is exculpatory evidence? So this is any evidence that is favorable to the defendant in a criminal trial and clears or tends to clear the defendant of guilt, right? So this is going to be like if the survivor says that they were lying or that they know it's a different person, that sort of thing. This isn't going to be things like if the survivor changes their story a little bit, that's not exculpatory evidence. That's like pretty normal um, trauma and the way that trauma affects the memory. This is going to be like the survivor is very clear about their intentions and that this is um, not the correct person. So when exculpatory evidence comes up, or if you're in a situation where you're like, I'm not really sure if this is exculpatory or not, the recommendation that we've received is just to use your best judgment. And so again, if someone's story is changing, that is really, really common with trauma. And so that's not typically going to be exculpatory evidence, right? So we want to make sure that we are really familiar with the neurobiology of trauma and the way that trauma impacts sexual violence survivors so that we have that knowledge to make a decision about whether or not information is exculpatory. All right, so the statute also talks about verbal or written consent of the victim to disclose information to other professionals and administrative support persons that the advocate works with, right? So like if I'm an advocate and I have a case that I want Sam's opinion on, so this is getting consent to ask Sam for her assistance. So the statute says verbal or written consent. Now VAWA says written consent, so we need to do the written consent. But we can get consent to work or to share information to ask for assistance with those we're working with. All right, and then I also want to talk about how privilege can be lost or waived. And this could happen on purpose and this could happen by a mistake. And so privilege can be waived, right? If a survivor signs a release of information and they want you to waive this privilege for whatever reason, that can happen. But I also want to talk about things that can be accidental. So if a survivor makes information public or not completely private, the court may say that they have waived their right to protect their information, right? So this is why sometimes when someone has an ongoing legal case, they'll say, I can't talk about it, I have an ongoing legal case, right? Because they don't want to accidentally waive their right to privilege or their right to privacy. So that like if someone is posting on social media about their case and that becomes a known thing by the defendant, they might try to argue that they have waived their right to privilege and the court may agree with them. Another thing that can happen is that anytime a survivor requests an advocate to disclose information, there is always a risk, right, that the privacy can be violated. I'm not saying not to do this because that can be really, really important for our work and trying to assist the survivor, but that it should be known that there is some risk when we share information. And then the other thing I want to talk about is if an advocate acts in another role, right? So for example, if they act as an interpreter. I've heard this come up with different advocates over the years. And so let's say for an example, you are a victim advocate and you are the victim advocate that's housed in a police station. And law enforcement has a survivor that they're working with, but the survivor speaks Spanish. Then the law enforcement officer does not speak Spanish, but they know that you do. And so they come and they ask you if you can interpret for them. Please always, always say no. If you interpret for them, you can lose your privileged communication and then they cannot work with you as an advocate, right? If that happens, you do need to call for an interpreter. Survivors have the right to an interpreter at all times. And so please call for an interpreter and do not risk the waiving of your privilege because that can be very, very harmful for survivors. If you are a member of the coalition, you will have access to the language line, which is a phone line of interpreters for free. And so if you need access to that and you're not sure how to get access to that, please send us an email and we can help you figure that out. But it's one of the benefits of membership is access to interpretation services. Okay, so now we're going to go through some different hypotheticals. So get ready to type in the chat. So the first hypothetical, you are working with a victim, Jane, who initially discloses that she was sexually assaulted by her friend, John. The police were called and a criminal case is pending. Jane tells you the details of the case and tells you she's going to make sure John pays. So what are your obligations in this situation and what do you do? So beyond all of your advocacy that you're providing, do you have any obligations to report anything? What do you do in this situation? So please put your answer in the chat. Or I'm seeing no obligation to report. Do folks agree with that or disagree? No obligation, agree, no obligation. Great. You are all correct. There's no obligation to report. There is no exculpatory evidence here. So your only role here is to provide the best advocacy that you can. Hypothetical number 2, so very similar case. You are working with a victim, Valeria, who initially discloses that she was sexually assaulted by her friend, Michael. Police were called and a criminal case is pending. Valeria tells you that the details of the case and tells you she's going to make sure Michael pays for everything he put her through. She tells you the details multiple times and they're different each time. What are your obligations and what do you do? Okay, so I'm seeing no obligation to report, nothing, no obligation. Awesome. You are all correct. So changing details is a common occurrence when it comes to trauma, and your best judgment tells you there's no exculpatory evidence here. And then just a reminder, because I've been seeing some questions come up in the chat, please put your questions in the Q&A function because I cannot see all of the questions. Like I will just lose track of them and I won't be able to answer them. So just a reminder to use Q&A. Okay, so now we're going to talk briefly about mandatory reporting. So when it comes to mandatory reporting, advocates are mandatory reporters of child abuse. So I've listed out everyone in the statute who has the responsibility to report. So the important ones to be aware of for you all is the domestic violence victim advocate and the sexual assault victim advocate are both mentioned specifically as mandatory reporters. And then also any person who is employed as the immediate or next higher level supervisor to a person who's listed. So you as an advocate are a mandatory reporter and so is your boss, right? So this means that you will need to make sure you're coordinating those reports. And this is in there just so that folks don't slip through the cracks. So when do you report child abuse? Right, so when you have the reasonable belief that a minor has been the victim of physical injury, abuse, child abuse, reportable offenses. A reportable offense, there's a whole list of them to look up, but they are all, I think almost all of them are all the sexual violence offenses, so any form of sexual violence and neglect. And so all of these things that were not an accident or not explained in the medical history. And then reasonable belief that an infant has been denied or deprived the necessary medical treatment, surgical care, or nourishment with the intent to cause death to the infant. Right, so those are all the ways, all the things that you would need to report. A report is not required so under Arizona law, the age of consent for sex is 18. However, we know that teenagers are having consensual sex before the age of 18. And so this is included in the mandatory reporting. So if a teenager between the age of 14 and 17 is having consensual sex with another teenager who is also between the age of 14 and 17, and it's consensual, you do not need to report that. Technically, it is illegal for them to be doing this, but you do not need to report consensual sex between these teenagers. A report is also not required if the minor is of elementary school age and they are injured at school, right? So if someone is playing on the monkey bars, they fall off and they break their arm at school, you do not need to report this. So who do you report to? You report to a peace officer, so that's law enforcement. You report to the Department of Child Safety, or you report to tribal law enforcement or social service agency if it is a native minor that you are reporting on and they reside on a reservation, right? And so you would want to report to both the law enforcement and DCS if it is the parent or guardian of the child. But if the report is not related to the parent or guardian, then you only report to law enforcement, right? So if someone is sexually assaulted, so a teenager, say, is sexually assaulted by another teenager that they go to school with, you would report that to law enforcement, but not to DCS. If you call DCS, they will just tell you to report it to law enforcement, right? All right, I'm seeing a question. I've had a DCS hotline ask about other incidents of domestic violence abuse in the household when I call to report child abuse concerns. Do I have to disclose other incidents of DV that a victim shares with me unrelated to the child abuse that I'm calling about? Sam, I'm not sure if you want to chime in on this one, since I think you have a little more experience with the domestic violence side of mandatory reporting. I would say you would only need to disclose the child abuse because I think it would be a privacy violation to disclose the other types of domestic violence.
Yes. I agree.
And then I see regarding files, I've seen some programs compile files with a section that says not subject to subpoena. Does that really protect the section of the file? That's a good question, Peg. So the privileged communication statutes that I just went over, that's what protects you from the subpoena. So the purpose of those laws is to protect advocates from subpoena. So all of your files should be protected from subpoena. You can still be subpoenaed, but it's most likely not going to hold up in court. And that's why it's really important to have a policy about what to do when you are subpoenaed and to have a lawyer for your organization who is very familiar with these privileged communication laws and subpoenas, so how to respond to subpoenas. And so consensual sex between teenagers, so how do, Sandra, I'm not totally sure about your question. So how do you know if there is consensual sex between 14-year-olds and whether or not it includes the LGBTQ community? So yes, the statute, it would include the LGBTQ community. So if teenagers are having consensual sex regardless of their gender or sexual orientation, and it's consensual, then that is included. You would not need to report that. And you would know, as far as how to know if the sex between a 14-year-old and another 14-year-old is consensual, is I would say if they tell you, right? If they tell you it's not consensual, then you would need to report it. But if they tell you, so something, I think that a common thing that happens is if we're out in the community and we are providing like prevention education and we're talking about consent and sex and healthy sexuality out in the community as part of our role as an advocate, sometimes we will get teenagers who want to talk to us afterward and they will tell us that they're having sex with their boyfriend or their girlfriend. And so if they tell us they're having sex with their boyfriend or their girlfriend, you can assume that's consensual, right? If they tell you that they are having sex with their boyfriend or their girlfriend and that they did not feel like it was consensual, right? And they talk about maybe being pressured into it or not feeling comfortable with it. You might want to have you're going to want to talk about your mandatory reporting obligations before this conversation, but you might want to have another, like a deeper conversation with that person to find out if you need to report that as sexual violence or not. Great question. Okay. So how do you report child abuse, the mandatory reporting? So like I mentioned, if a perpetrator has care, custody, or control of the minor, right? So if they are like their guardian or their parent, you report that to DCS. And so you can report that online. I have the link here, and I will share these slides with you all after, as well as their telephone number. And the statute says you need to report immediately. If the person is anyone else, right, so say it's their boyfriend or someone from school or another adult in their life, but not their parent, then you would contact a law enforcement agency that has jurisdiction. And then again, you would also do this immediately. Okay, so I see another question is, if the minor is having sex with someone who's older than 18, would you have to report? Yes, you would have to report. And so if, let's say someone is 17 years old and they are having consensual sex with their partner who is 18 or 19 years old, you do need to report that, even though it is consensual. But it is very likely that it won't hold up in court. So there is the Romeo and Juliet defense, which doesn't mean it's legal, it's just a defense. That's an accepted defense. And it says if someone is within 24 months, so 2 years of age, if they go to the same high school, then that's like an acceptable defense as to why an 18-year-old and a 17-year-old would be having consensual sex, right? It's called the Romeo and Juliet defense. If, like, say it's like a 16-year-old and a 20-year-old, right? That's 4 years difference, so much bigger than the 2 years. The 24 months that's allowed in the defense, that one will hold up in court even if it's consensual, and that will be considered statutory rape. Great question. Okay, so what must a report for mandatory reporting of child abuse contain? So you're going to want the names and addresses of the minor and the minor's parents, or the person or persons having custody of the minor. You're going to want the minor's age, the nature and extent of the minor's abuse, child abuse, physical injury, or neglect, and then any evidence of previous abuse, child abuse, physical injury, or neglect. And then any other information that the person believes may be helpful in establishing the cause of the child abuse, right? So you may not have all of the information here, but include in the report as much information as you possibly can if you have it, right? Most important would be like the names of the child and the parents, and the type of abuse. All right. So before we do the hypothetical, there's one more question. And so the question is, my previous question about the age of consent apply to 14 and 25-year-olds. So Sandra, it's going to apply, you're going to need to report anytime a minor has sex with anyone who's 18 years or older, right? That is always going to be considered sexual violence under Arizona law, right? So it does apply. If it's consensual, there is the 2-year age difference window where it's accepted as a common defense, that it's most likely the case will be thrown out and not pursued by prosecution. It can still be pursued by prosecution, but it's most likely not going to be. But if a 14-year-old and a 25-year-old are having sex and the 14-year-old believes it's consensual, that is definitely going to be considered sexual violence. and that is something that may also be prosecuted, right? It's always the prosecutor's decision, but that is definitely something that would not apply. The Romeo and Juliet defense would not apply to a 14-year-old and a 25-year-old, so that would be considered sexual assault. And then Sam typed in the statute into the chat for me, so thank you so much for doing that, Sam, if you want to check that out as well. And Sandra, I'm happy to have, if you want to send me an email or call me afterward, we can talk in more detail about this as well. All right, thank you, Sandra, for your questions. Okay, so now we have another hypothetical. So you are working with a victim, Sandra, who discloses that her daughter, Jordan, who's age 10, was sexually abused by her partner, Olivia. You are the first person Sandra has told about this, and you have not talked to the daughter. What are your obligations and what do you do? So please answer in the chat. All right, so I'm seeing a lot of reports and one no obligation to report. So the correct answer is you have to report this, right? Because the daughter who's age 10 is the one being abused. And so because she's a minor, you have to report. If Sandra was talking about her own abuse, you would not report that, but because the daughter is a minor, you have to report it. Okay, so now we have hypothetical number 4. So as part of your program's prevention education, you are teaching teens about consent and healthy relationships. A 15-year-old girl tells you she's having consensual sex with her 17-year-old boyfriend. What are your obligations and what do you do? All right, I'm seeing no obligations coming in. Great, yeah, no report here. So that's correct. So there's nothing that you need to report. Consensual sex that only involves minors between 14 and 17, right? If they're both between the age of 14 and 17, you do not need to report this, right? So it is important to keep in mind, though, that when the 17-year-old boyfriend turns 18, if that 15-year-old girl talks to you about that, then you would need to report that, but only if the boyfriend is 18 years or older. All right, last hypothetical for this section. So a 16-year-old boy comes into a sexual assault program looking for advocacy services. He says he came in because he was looking for resources for a friend. You explain your mandatory reporting obligations. He frames everything in hypotheticals, but gives you very explicit details. He hasn't specifically said that he is the victim, but you are concerned he might be. So what are your obligations in this scenario? What do you do? So I see one report. Do folks agree with that? Or do they disagree that you would not need to report this? Okay, so I see one person who said they would not report. There's not enough information to report, and I'm seeing a few people who say they would report it. So we've got a mix. Cool. Usually I feel like everyone agrees on this one. So I like that we have a mix here because it is a mix. So this is tricky. So I personally would not report if I was the advocate in this situation because it's really, really vague. So reasonable belief is not a well-defined concept legally. And so what you're going to want to do is your program is going to need to have a very well-written policy and protocol for how to handle the situation. Because you might think that this person's the victim, but you've told them your mandatory reporting obligation and they chose to frame everything in hypotheticals and to not identify as the victim. And so it's very unclear if you would need to report this or not. If you do report hypotheticals, you want to make that clear to the 16-year-old that you will report a hypothetical so that they can decide whether or not they want to share this information with you. Right, so if this was me, I would not report this, but you really want to make sure that you have a really clear policy with your agency as to why you would report this or why you would not report this. And it's important when you're writing these policies to talk about your organization's values and your mission as to why, as part of your rationale. So if you are an organization that provides sexual violence advocacy, we know that the highest age window of survivors is like 16 to 24, right? So 16 to 24-year-olds are the age window where survivors are most at risk. And if we want to serve survivors of sexual violence, then we need to make sure we're serving minors and that we're having really clear policies about minors, because otherwise we're going to miss a big window of who survivors are and who's most at risk. And so that could be a reason that we would say we don't report hypotheticals. Now, the minute this boy tells us that he is the survivor, you would absolutely have to report it. But because right now he's talking in hypotheticals, you may not need to report it. So again, really, you really want to have that good, firm agency policy as to why you are or you are not reporting. All right. Are there any other questions about this hypothetical? I think this is like the trickiest hypothetical we have today. So please let me know if there are any other questions or discussion that we want to have about it. All right, so now we're going to talk about vulnerable adult abuse and whether or not you need to report. So this again is a little tricky because sexual violence and domestic violence advocates are not listed as mandatory reporters. However, social workers are. And so we know a lot of folks overlap and they're both social workers and advocates, right? So that's up to you to know if you are a social worker. If you are a social worker, you do need to follow the mandatory reporting for vulnerable adult abuse. If you are an advocate and you are not a social worker, you do not need to report vulnerable adult abuse. So who is a vulnerable adult? So these are the quotes from the statute. So a vulnerable adult is any individual who's 18 years of age or older who is unable to protect himself from abuse, neglect, or exploitation by others because of physical or mental impairment. And a vulnerable adult also includes an incapacitated person. So an incapacitated person is any person who's impaired by reason of mental illness, mental deficiency, mental disorder, physical illness or disability, chronic use of drugs, chronic intoxication, or other cause, except a minority, to the extent that he lacks sufficient understanding or capacity to communicate responsible decisions concerning his person. Okay, so this definition is very confusing, and I have tried to investigate this definition a little bit better. And the person I spoke to at one organization said that the definition is really meant to be a narrow subset of people, right? And so a vulnerable adult, sometimes we think of this as any person with disabilities. I don't think that's true. I think there are many, many people with disabilities who are able to make a decision about whether or not they want to report. And so the line here is a little bit blurry, right? So I would definitely say anyone who has a legal guardian, folks who may be in different institutions, right, are going to be considered vulnerable adults, but not every single person with a disability would be considered a vulnerable adult. But like I said, it's very confusing, and it's important that if your agency is reporting these kinds of abuses, to have a clear policy about this. And so I see another question. I think it's related to the hypothetical. And so with the hypothetical about the 16-year-old boy, if the boy tells you that he is a survivor, you would absolutely need to report it. Yeah, so while he's framing it in hypotheticals, there's that gray area where you may not need to report, but once he tells you he is the survivor, then you would definitely need to report it. Okay, so back to the vulnerable adults. So when do you report vulnerable adult abuse? So this is when you have the reasonable basis to believe that abuse or neglect of the adult has occurred, or that exploitation of the adult has occurred. So again, only if you are a social worker. Advocates in general who are not social workers do not need to report. However, you may report, so if you're not a mandatory reporter, but you still have a reasonable basis to believe this abuse has occurred, and you feel like it's your ethical duty to report, then you can report if you want to. I really would recommend as advocates that if you do not have the requirement to report, that you do not report, because there are one of the barriers that many people with disabilities don't seek services is because they don't want to report, the same as other survivors, right? And so it can be important to be able to hold that space for them as being able to be that one person they can talk to who will not report it to law enforcement, right? So I would really want us to think about that when we're developing our policies, because that can be a really important barrier that prevents survivors with disabilities from accessing our services if we are reporting to law enforcement. Okay, so if you are required to report, you would report to a peace officer and to the Adult Protective Services Central Intake Unit, right? So law enforcement and APS. So how to report. So this is how to report to APS. This is APS's reporting telephone number, and you can also report online. And the statute was updated, I think, a year ago now. It used to be 48 hours report. Now it's an immediate report. So make sure that you have updated your policies to that immediate report and that you are reporting immediately. So what must a report contain? So you're going to want the names, addresses of the adult or any person, and any person having custody or control of the adult if you know it. You'll need the adult's age, the nature and extent of their vulnerability, the nature and extent of the abuse, neglect, or exploitation, and then any other information that the person who is reporting thinks is helpful for establishing that cause of abuse, neglect, or exploitation. All right, so now we have a hypothetical. Someone calls your hotline looking for resources because her adult brother, who lives in a group home for adults with intellectual disabilities, was touched inappropriately by one of the care workers. What are your obligations? What do you do? All right, so I'm seeing a lot of obligations to report. Does anyone disagree? Would anyone not report this? All right, I'm not seeing anyone disagree. However, I will say it depends. If you are an advocate and you are not a social worker, you do not need to report this, right? So you only need to report if you are a social worker or any of the other professions listed, right? So if you're a healthcare provider, anything like that, you would need to report it. But as far as sexual assault advocates go, you do not need to report it unless you are also a social worker. You still may report it if you want to, but it's not required. And it's really important, since it's not required as an advocate, to have a conversation with this person who's called, right, about their reporting options. Because we don't want to make the decision as to whether or not to report for a survivor without them involved. And we would never make the decision to report for a survivor for any other survivor, right? Unless they were a child. With the child, we are legally obligated to report, but with a vulnerable adult, unless we are also a social worker, we are not legally obligated to report. So we really, if we feel we need to report this, we really need to have a conversation with this person who's called on the hotline about what that's going to look like. Okay. So there are a few things that come up that I think sometimes advocates think they have to report, but you actually don't have to report. So advocates do not need to report when the client is a danger to others. Only mental health providers, I believe, are required to report this, but sexual and domestic violence advocates do not actually need to report when a client is a danger to others. Different professions have like ethical duties, right? So depending on like if you're a social worker, for example, you may have like in your social work ethics that you have to report this. And so that's fine. And your agency may have a policy saying you need to report this. But it's also something to think about because we are not legally required to report this. We can have different conversations about what is important to our values as an organization as to whether or not to report this. Some places I've heard they don't want to report this because if you report this, that can violate trust between the survivor and the advocate, and we don't want to damage that relationship. Other places they do want to report this because of that danger to others. And it could also depend on the severity of the situation, right? So that's just something to keep in mind. The other place that advocates are not required to report and should not be reporting is when there is an injury from an illegal act, right? So healthcare providers are required to report this, right? So you'll hear us talk about gunshot, stabs, or material injury. That's what healthcare providers are required to report. Advocates are not required to report this and should not be reporting this because then we would have to report every single incident of domestic violence, every single incident of sexual violence that comes into our program. And we absolutely cannot be doing that, right? We only, it's always the survivor's decision whether or not to report if they're an adult, right? Okay, so another question for the chat. How do you talk about your confidentiality policy and mandatory reporting obligations with clients? When do you do it and what do you say? So please just type out what your kind of spiel is. Are y'all typing in the chat? I don't see anything coming through. All right, I'm seeing a couple people have talked about the very first thing that you talk about in your conversation at the beginning, during intake process. That's when you do it. Yeah, what do you all say? So the beginning, that's great. always do it at the beginning, because you never want someone to say something that you have to report and they don't know you have to report it. But what do you say? All right, I'm seeing a few people saying that they're new, and so they really want to see what other people are saying. Okay, so I see we explained that we are mandated reporters based off XYZ. It's coming in too fast for me to read. I don't get to see it anymore. They want to let them know at the beginning that they're a mandated reporter. I think it's also really important to say what exactly you have to report. So I saw someone say that they need to report child abuse or abuse to others. You don't need to report abuse to others, only child abuse, right? So you want to do this at the beginning, and you want to say, if I learn that there's a child who's being abused or is in danger, I would need to report that. If that does happen, we can talk together about the options, and we can report together, right? So if you're working with a youth and they disclose something that needs to be reported, you can work with them to report. You can give people the option to report it themselves, and you will still need to file your own report, but sometimes it can be really helpful if we tell survivors they can report it as well. When we talk about your information being confidential, we want to make sure that that's really clear as well. And I totally agree with everyone who's saying to do it at the beginning, during intake, right? And it's also important to bring up probably every time you meet with them, just to remind them about your obligations, because I don't know about you, but I am probably going to forget half of the things that are said during intake, right? If I am going to a new service, I'm not going to remember everything. And so you'll want to make sure you're reminding them about what your obligations are throughout the time that you're working with them. All right, I'm seeing a lot of really good examples here though, so this is great. All right, so now we're going to shift gears a little bit. Are there any final questions about privileged communication, mandatory reporting obligations, anything like that before we move on? Okay, so someone said they're a social worker, so do they need to report the abuse of others because of ethical standards? So I'm not a social worker, so I am not familiar with the ethical standards that you would need to report. The reason I would say the abuse of others is probably something you don't want to report is because if you had to report all types of abuse, you would have to report all of your clients as being victims, right? And we definitely don't want to be doing that, because it's the client's decision whether or not they want to report. And so that's why I'm saying you don't want to do that. But if someone is a social worker and is more familiar with those social work ethical standards, please feel free to put in the chat what you all think as well. All right. So if there are no more questions coming in, oh, I'm seeing a few more questions come into the chat. Please put the questions in the Q&A so I don't miss them, but I'm going to try to get to the questions in the chat. One person says, I have a concern about youth calling the crisis line to report sexual abuse, but we don't have enough information for a report. My concern is I think that there is a temptation to press for more information as opposed to creating space for the client. Yes, this is a really good question. So one thing that is really good about crisis lines for a lot of people is that you don't give out that information, right? Like, so a minor can call a crisis line and not disclose that they're a minor. They can receive advocate support, but then not have to have a report made on them. And so I don't think it's an advocate's role to try to find out how old people are when they're calling the lines. I think it's the advocate's role to provide advocacy when they're getting those calls. So we don't necessarily want to be pressing for more information because a teenager, like a 16-year-old, they might be very familiar with your program, and they might know that if they walk into your program, you're going to report to law enforcement, right? Because they're a minor. But if they call you, you're not going to know if they're a teenager. So they're going to be able to get that advocacy without having to report. And that's a really important option for teenagers to be able to use. Okay, and then Mary Lou, I'm seeing you don't have to report victimization unless it's a minor, but if there are plans to injure yourself or others, you should. I'm assuming that's an answer to the social work ethics question. So thank you for that, Mary Lou. And so someone asked about they had someone call who wanted to kill herself, and they called the police. So they're wondering if that was the right thing to do. And so again, that's really, really tricky, right? Because I think it's really going to be on a case-by-case basis. So I don't think, unless you're a social worker, I don't think you're obligated to call the police because this person is suicidal. Or is having suicidal tendencies, but it is an important option that you can call the police if that's happening. So I don't think there's a right or wrong answer to do in that situation, right? And so I think it's really going to be case dependent and case by case whether or not you should report. And like I said, legally, you do not need to report. But your ethical standards for your ethical standards for your profession may require you to report, and your organization may require you to report. Okay. The only thing I would say is that we do not want to report on behalf of the survivor, right? So if someone calls us about their experience of domestic violence or sexual violence, we do not want to report that to law enforcement, right? Okay. Any further questions about the mandatory reporting or privileged communication? Okay, I'm not seeing anything come through. So now we're going to shift gears a little bit and really focus about how can we further protect confidentiality when we're in rural settings or really close-knit communities, right? So now we've gone through all of the legal obligations, but how do we really do that to the best of our abilities in rural areas? So I want us to do a Mentimeter poll. So if you've taken one of our webinars recently, you've probably done this before. So I want you to get out your phone or open another browser on your computer, and you're going to go to menti.com, and you'll enter the code 3837081. So if Sam, if you want to put the code in the chat, I'd appreciate it. And then you'll answer the questions that come up. So I'm going to bring the Mentimeter up, And the code will still be on the screen. So you should still be able to see the screen and the code. So it's 3837018. And so what are the main confidentiality challenges you face in your rural or close-knit community? So just type your answers into the browser that you have open. Proximity, location of business, gossip. Yeah. Town is small. I feel like the rumors and the word of mouth, that's all under gossip. Everyone knows everyone. I feel like that's also under gossip. Um, I grew up in a town of 2,000 people, so I am very familiar with the everyone knows everyone gossip that happens. Family ties, absolutely. Right, sometimes in rural communities, there's like a few very well-established families that have been there for generations, and everyone knows everyone who's related to them, all of that. Boundary issues, right? Sometimes boundaries can be really difficult when everyone knows everyone, right? Because like um, if your partner's ex-girlfriend comes in, right, and you know this about them and they know this about you, like how do you handle that situation? Or if you know someone really, really well and they come in, what do you do in those situations? There's limited services, absolutely. Yeah, work colleagues discussing, yes. I think it's so easy to accidentally reveal who you're talking about when you're talking with your colleagues about different cases, and people can really figure out who you're talking about immediately. So we got to be really, really careful when we're talking about the different cases we're working on. Judgment, trust, absolutely. Great. Thank you, everyone, for participating in this. Um, I think we're going to talk about some of these as we go. So different strategies to really address the everyone knows everyone and the location of your program, all of that stuff. Okay, so this, I want to know, what are your top tips for confidentiality in your area? So this, I think you can write out as like a complete sentence if you want, or a few words if you want. But what are your top tips? Because I feel like you are the best experts of your town and your area. So what are your top tips? So I see training. So I'm going to assume training staff on confidentiality and making sure that everyone's really, really clear about what confidentiality is and how to do that. But so what do you personally do when you are trying to protect someone's confidentiality in your program? Yeah, so changing the name of the participant in different systems, right, so that the anonymity is preserved. Setting boundaries right away, right? So if someone comes in and you know that person, being really clear about what your role is, what your boundaries are. When you see me in the community, we don't have to talk and you don't have to approach me. Yeah, so really explaining that to survivors. So you can't, like, the survivor can choose whether or not they want to approach you or acknowledge you, but make sure that that's their choice. Um, don't share things with other people. Absolutely. Um, oh, it's moving and disappearing. When you see the client in public, don't say anything unless something is said to you first. Meet with them at different locations away from the office or public spaces. That's a great option. right? Being able to have flexibility about where you meet. Ensure information is only shared with the stakeholders, right? And by the stakeholders, I'm going to assume the people who you have that ROI, the release of information with, right? The survivor signed a release of information. You can only share with those people. Only get confidential information if you need it, right? So we don't need to know every single detail about a person. We only need the information that we need to provide services and for our grant reporting. Absolutely. Being discreet, definitely. Talking about it first thing after making sure the survivor knows they are safe and their information isn't going anywhere that they don't want it to, right? So I really like how you all are being really upfront about what, when you're talking about your boundaries, your role, and confidentiality. I think that's great. Okay. I don't think I can get to all of them because they're moving and I can't keep track, but I think these are really, really good suggestions and I really, really like them. Okay. Okay, now we're back to the PowerPoint. Okay, so one of the top things you all mentioned was that gossip and how everybody knows everybody, right? So everyone knows where your program is located, right? You might have a confidential location, but people who've been around your community for a long time, they probably know where your program is, even if it's a confidential location. And so if they see someone walking in the front door, they might make different assumptions about why they're walking in the front door. And so many survivors will have concerns about that. And so one of the things that you all suggested was having those neutral places to meet, right? Letting survivors choose where to meet and where is a comfortable, safe place for them, right? So there's a lot of different options that you all can use. I think a library is a pretty good neutral place. There are places of worship people may feel comfortable meeting at. Not everyone's going to feel comfortable meeting at a place of worship, but I know lots of small towns have many different places of worship, and many of them offer their space as community space to use, right? So when I was a kid, the church that my parents go to, they had yoga in the basement every Saturday, I think, right? And so they just opened it up as a community space. And different places of worship may feel more comfortable to others. But so that's something the survivor can choose if you have a good relationship with different faith organizations. You can arrange to meet in those locations if you want. Health clinics can be a more neutral space to meet, right? Because you're just going to the doctor. You're not seeing an advocate, you're going to the doctor. It's different. And community centers. So if your community has like a community center, community space, that could be a more neutral place to meet as well. You want to make a plan with the survivor if they're recognized coming out of your location or going in. And so this could be something like, if someone asked them why they were at your location, they could say things like, oh, they were dropping off donations, or they were interested in volunteering for your program, or they were asking about information for a friend, right? Because then the survivor's kind of controlling what that story is about them going into your facility, rather than that the idea is that everyone who comes into your program is a survivor, right? We want to take extra caution on personally identifying information, right? And I think you all at the beginning of today talked a lot about some different options that may be considered personal identifying information. So I think you all sounded like you have a really good handle on that, which is great. So if possible, offer a different advocate if you and the survivor know each other and the survivor feels uncomfortable working with you because of that. That might not always be possible. So maybe there are two advocates who are working in your program and the survivor knows both of you, right? So that might not be an option, but you can always give the survivor choice over which advocate they want to work with if that's something you can offer. And you can offer, since we're kind of in this new virtual age with COVID, it might be easier to refer them to another program that's offering virtual services, right? If they don't feel comfortable talking to anyone at your program. You want to reemphasize your confidentiality policy, which I know all of you brought up already in the Mentimeter. And then you can also double up on things like your support groups and education groups. You can double up the purpose, right? So maybe you call your support group or your education group a sewing circle, because going to a sewing circle is something that is more acceptable to do in your town, and it's going to be viewed with less suspicion as to why someone's going there. Or you could do a basketball group, right? And there are other options that maybe aren't as gendered, right? So I feel like sewing and basketball might feel like only girls can go to one and boys can go to the other, but we can make that not the case as well. Oh, I see. So one of the questions I'm getting is that everyone in the community knows who I am because I am a survivor. Yeah, and I think that is definitely something that comes up in rural communities. Like, the community knows that you're an advocate or that you're a survivor, and we can't really cover that up, right, if we're the advocate, because we're out in the community and we are trying to outreach our services in the community. And so then what can happen is if someone's talking to us, people might assume that we are providing services to them. And so that can be really tricky, which is why we want to make sure we're having those neutral places to meet and private places to meet, right? So if the survivor feels comfortable meeting in a more public space, that's up to them. Maybe they want to meet at a coffee shop, and that's up to them. But in these other places like libraries and community centers and health clinics, you can get private rooms to meet in. When you develop relationships with those places, libraries often offer rooms for free to anyone in the community, and so you can have those more private spaces as well. Okay, so we also want to make sure we're protecting survivors while we're doing outreach, because when we're outreaching in our community, especially if people know you are the advocate, and they may assume that people talking to you are survivors, we want to make sure that we're protecting survivors' identities when we're outreaching. So we want to also do our outreach in those neutral spaces, right? If we have community bulletin boards, we can post our information there. I feel like libraries always have a ton of information and community notice boards. We all want to do big things for Sexual Assault Awareness Month and Domestic Violence Awareness Month. But if we're only doing outreach for sexual violence during Sexual Assault Awareness Month, and we're doing a big sexual assault awareness event, and we're not really outreaching our sexual violence services at any other times, people who come to those events or who are walking by those events as they're happening, they may make a lot of assumptions about why people are attending those events, right? And so we might not be as successful in our outreach as we want to be. So instead, we also want to do outreach at neutral events, right? So at community fairs and different community events that are happening, we don't want to just do our outreach related to sexual violence events or domestic violence events. We can also use more traditional media and non-print media to do our outreach, as well as online media. Sometimes these different small towns, they might have like a small town paper that might be more effective and is much more neutral way than approaching someone in person to do outreach. We can use other service providers to pass on information when we are advertising our services at homeless shelters or health clinics. that those are not necessarily related to domestic and sexual violence. So we can absolutely outreach there. We want to form relationships in the community with different community leaders and trusted individuals, right? Because then if those community leaders are like, this is an acceptable topic to be talking about and to be discussing in our community, other people might feel more comfortable coming up to you and coming up to your program. It can also be that those are the people that survivors are turning to first, right? I know a lot of times in small communities, the faith leaders can have a really important role where maybe the first time someone discloses this to their faith leader. And so having really strong relationships with those faith leaders so that they are able to refer to you and to respond appropriately can go a really long way. And then we also want to assess if your outreach strategy is reaching the demographics of your community, right? So are there any demographics that you're not reaching, right? Are you only reaching the easier to reach people? And so we want to look at who is in your coverage area, what are the different social groups that are there. So maybe in your community, you have a particular immigrant community in your community, but you're noticing that they never come to your program, they're not coming to your events, no one in this community comes, so you're going to want to reassess whether or not your outreach strategy is working. Okay, and I saw, I think there was a question that accidentally got dismissed before I was able to answer it. Someone asked, is there a policy when you cannot meet outside the office? Yeah, so if your organization has a policy and you're not allowed to meet outside the office, I would encourage you to talk to your supervisor about if you can change that policy, because providing options to survivors about where you can meet can be really important. I know sometimes we are also concerned about advocate safety, and we want the advocates to be safe as well. And so we may have these policies that we can only meet inside the office, but that can be really limiting to survivors. So if you want to have this conversation with your supervisor, or if you want to talk to us more about different strategies, feel free to email me after the training and we can talk more about that. Okay. Another thing that we can do in rural communities is have flexible transportation options available. So public transportation may be non-existent completely in your community, right? The town I grew up in did not have any public transportation, except maybe the school bus, if that counts. But there was no public transportation to get around. And I grew up on a farm out in the middle of nowhere. So we may want to be providing transportation options, right? Whether we have a vehicle where we can provide, we can drive to meet a survivor, or we can have someone use that vehicle to pick up survivors and bring them. That can be really important. If we have these agency-owned vehicles, we want to make sure that they are really nondescript, your run-of-the-mill, looks like everybody else's vehicle, and that they're unbranded, right? We don't want to have the branding of our agency on these vehicles, because that's just going to announce to whoever is seeing where we're parked what's going on, or people may feel very uncomfortable getting a ride from that vehicle, right? Some places have volunteer-based transportation programs, right? So they have volunteers who are able to provide this transportation, right? And this could be to get a medical forensic exam. This could be to come to your program, right? So that can be an important option. Relationships with local cab services and gas stations can be important. So you can have, if your town or area has a cab, A taxi service, you could use that instead of an agency vehicle because um, taxis are pretty, no one's going to know where you're going if you're getting into a taxi, right? For the most part. With a gas station, you can have different gift cards or ways that survivors can get gasoline for their car if that's an issue. Um, you may need to write into your grant that you want to get prepaid credit cards instead of gas cards because sometimes gas cards may give away that this person is a client or a survivor because if the gas station, if you have like one gas station in your town and they have a relationship with you and they know that they have a relationship with you, but they don't have a relationship with any other organization, everyone who gets a gas card, they're going to be like, oh, this person is a client of this SV program, right? So if we get prepaid credit cards instead of gas cards, this could be a way to reduce that assumption. Sometimes your grants might require it to be a gas card, but so we want to potentially try to write that into our grants, and we can also pay for it with our unrestricted funds. So this is another reason having a little bit of extra money that can go to any type of survivor service is important. Um, and then we also might have satellite locations. So maybe we have a big kind of main location for our program, but then we have satellite locations across the county that are designated places that we can meet with clients or set up a little office. Right, so that can be a helpful way to meet with clients, especially if we have different policies about having to meet in the office. If we have these satellite locations set up as like designated safe places to meet, that could be another option. Okay, so I'm seeing a question that says, can you talk a bit about texting clients, boundaries, and protection? Yeah, so it's really important that we have these really clear boundaries with survivors. Texting clients, I think if you have an agency cell phone, which I really hope your agency is providing you with a cell phone, it's very important for tech safety and for your own boundaries. I think it would be totally fine to text people on your agency cell phone. But if it's your personal cell phone, I would say that decision's up to you. But it can be very difficult to maintain boundaries if you're giving out your personal cell phone number, right? We don't want to feel like we have to answer our personal cell phone 24/7 because survivors are texting us on that. That's not going to be healthy for you in the long term. So I personally would recommend not doing that. But again, I think it is your decision. When we're talking about boundaries, it can be even more difficult in rural settings because if we're friends with someone or we're acquaintance with someone, they may feel that your boundaries are too strict or your role is too strict when you try to enforce those boundaries, which can be difficult. So I think it's really, really important to just be clear upfront about those boundaries and about your role. And yes, the survivor should be making the decisions about whether or not to acknowledge you in public, all of that sort of thing. But that doesn't mean that they like have a right to your time 24/7, right? If you are off the clock and there's another advocate available, they would be wanting to call your hotline, right? And talk to the other advocate who's available. And then protection. So safety can be very tricky, right, as advocates, and we always want to make sure that we are safe. And I think that can be really case by case. It's important for your organization to have good policies about ways to protect your safety when you're doing mobile advocacy, right? What are safer places to meet up at, right? Like libraries or other more public places that still have that element of privacy to it, and maybe what are places that might not be as safe, right? Sam also recommended in the chat that Google Voice is a really great option. So you can set up a Google Voice number to field your calls and text messages, so that if you don't have a work cell phone, you can set up that Google Voice number, so that way that's your work number, and that you can have that barrier between your texting and your personal phone calls and your work calls and your work texting, right? And I think Rebecca actually suggested it, and she also said you can mute it after hours. That way also people don't have any connection to your personal number. So that's a really great idea. Awesome. Okay, so now we want to talk about mobile advocacy. So transportation is great. Being able to go to the survivor is a really great option for a lot of folks in rural communities. So when you are doing mobile advocacy, it's important for the survivor to have a choice over where you can meet up. So like I said, your agency may have a policy about appropriate places to meet up, which is fine, and that's important for protecting your safety. But you can still give survivors that choice of where to meet. So what are some of the different risks of these different locations? So like meeting up at a restaurant or a coffee shop, there's maybe a risk of being noticed, just being seen talking to the sexual violence advocate. If you are a known person in the community, you may be overheard, but they may feel really comfortable in that space, right? You could meet up in other places as well that may have different risks. Like I said, plan for if the survivor is recognized, or if you are recognized as an advocate, right? So I know we've touched on this already, but when you are known as the person who is the advocate in your community, this can increase risk to the survivor being identified as a survivor. So we want to have a plan in place for why you're talking, right? And that plan could be like, oh, like you know each other from some other part of your life, or they are talking to you about how to get involved with your program. They want to volunteer, right? All of that sort of thing can be different options to say if someone is like, why were we talking to that person? It can be important to have a mobile advocacy kit. So this is just like having all of the things that you feel like you need for your mobile advocacy with you at all times. So this could be like having water or snacks or a notepad as well. When you are doing mobile advocacy, you're going to want to remove agency markers from yourself or from your car, right? So you might have a name badge that you wear in your program. And so you're going to want to take that off when you're meeting with someone out in the community, because if it has your name in your program, you're going to be immediately identified as the sexual violence advocate, and the survivor may be identified as a survivor, right? So we want to remove that to make sure that the survivor's identity is being protected. Sometimes we also have like different bumper stickers from our program on our car. We probably should remove those. We don't want those on our car because then people can identify us. And so if we're parked at someone's house, and they're going to be like, why was this person with the sexual violence program parked at so-and-so's house? And there's going to be gossip about that, right? So we want to make sure that our cars don't have our agency information on them. We want to use agency provided devices. If your agency does not provide devices, feel free to get in touch with Sam and I to strategize around this, because this is a really, really important thing that programs should be providing, because it really increases safety and security for advocates and for survivors. There's a lot of technological risk that comes with using our personal devices that can be harmful for both survivors and for us as advocates. And Sam and I are really interested in tech safety, so feel free to reach out to us if you want to talk more about that. We always want to make sure that our devices have really strong passwords and that we're keeping our agency devices up to date, as well as your personal devices. But for work purposes, keep your agency devices up to date. Sometimes when you're out in the community doing mobile advocacy and you get maybe a phone call from a survivor or a hotline call, your car might be the most confidential location to be, right? So if you need to take a confidential call, you can do that in the privacy of your car. Not great in the Arizona summers, but this is definitely an option that's available. We never want to leave files alone in the car. And when we are out and about, we want to be transporting files securely. So making sure our files are covered up, right? So putting them in like a briefcase that locks would be even better. And so that way there's no names or any information going out like that. We also want to think about what files do we actually need, right? Do you need all the files related to a particular survivor when you're working with them, or can those be left in the office, right? We probably don't need all the files that we think we do. We also, if we are transporting files electronically, we want to make sure our USBs are encrypted. These you can buy encrypted. They're a little more expensive, but definitely worth the investment to have that extra security. Because it can be really easy if there's no encryption to just like copy files from someone's USB. Right, I just realized what time it is. We're almost done. So I briefly want to talk about intake. So when we're talking about intake, this is the time when we're collecting a lot of information. And we want to make sure we're collecting only the information that comes up. Or that is required by our grants and the information that a survivor wants to disclose, right? We don't need to ask a million different questions unless like our grant really requires that information. And it's always the survivor's choice whether or not they want to share that information, even if the grant requires it. We also want to make sure we're keeping minimal records and documentation in our case notes. So for example, if a survivor is talking about the violence they experienced, maybe they talk about their use of drugs for coping, and maybe they tell you they're late on their rent. So how are you going to document that in your notes? Your case notes might say that you talked about different options. You talked about community resources and coping skills, right? So we don't need to talk about their drug use or their rent payments or anything like that in our notes. We want that minimal documentation. We also want to have clear data retention and disposal policies of electronic records. Okay, so I don't think we have time for you to respond to the hypothetical, but I think based on your answers from before, I think you all have a really good plan already. So in this hypothetical, you are a victim advocate in a small rural program and you receive a walk-in. The walk-in is someone you went to elementary school with and you both recognize each other. You were never close, but you know their family and friends. You're currently the only available advocate on duty. However, there is another advocate available if the survivor comes back later. What do you do? So a couple options that I have here is ask the survivor if they feel comfortable speaking with you or if they would prefer to speak with someone else, right? It should definitely be their choice. Explain your confidentiality policy and your role as an advocate and your boundaries, which we've covered. And then let them know who the other advocate is, right? So if they want to talk to the other advocate, make sure to tell them who that person is, because that person could be have a completely different relationship with them and they might even feel more uncomfortable talking to that person. You can also provide your hotline information. So if a hotline can be a little bit more anonymous. You can also provide national hotline information because then they are not going to be talking to someone in their town. And if one exists, you can refer to a nearby program. And like I said, with virtual options, this might be even more useful now than it was before. I also really briefly want to talk about sexual assault response teams. So I really want us to be careful about the information that is shared in sexual assault response teams, because the people who come, right, law enforcement, prosecution, and nurses, they all have different privacy rules, different confidentiality rules, and different discovery rules. So, right, if a law enforcement or prosecutor learns information about the case, that's called discovery, and they are required to tell that to the defendant, right? And we don't want the perpetrator finding out this new information if we're not supposed to be sharing it at all, right? We should not be sharing that with law enforcement prosecution unless the survivor tells us to. And I've been in many different SARTs where I have seen advocates bring up issues with a particular law enforcement response that happened, and then the law enforcement prosecution are immediately able to identify who the victim was in that situation. And so we really want to be careful in our small towns because it's so easy to identify who is who because of just the caseload, right? When we do things like case review or individual reviews of cases, we always want a release of information. That's very important. We want to share successes and challenges as a whole and not of particular cases, especially when it's really easy to identify who that particular case might be. And we want to be clear about confidentiality within the SART. Sometimes people's feelings can get hurt in SARTs because of confidentiality, right? So we want to be clear we're not sharing information because we don't value you as a colleague. We're not sharing that information because our responsibility is to the survivor and they do not want us to share the information, right? Our responsibility is always to the survivor the most, not to the sexual assault response team. And then we also should probably create a confidentiality agreement for the SART. So this will just say that anything shared in the SART will be confidential. Now again, that's not going to hold up if in cases of discovery and that sort of thing, but it can help add an extra layer of protection. Okay, so I don't think we have time for that video. But I have a few resources for you today. So there's the Arizona Address Confidentiality Program, which is just a confidentiality resource you can use if someone's address is compromised and they need a secret address. There's the NNEDV Confidentiality Toolkit. RAIN, the Sexual Assault Hotline, has a website that's dedicated to private and confidentiality laws in Arizona, so you can check that out. There's the Confidentiality Institute. Victims' Rights Law Center is an excellent resource, and the Resource Sharing Project Rural Toolkit. So that's it for today. Sam, if you can drop the evaluation into the chat for me. Please, everyone, please complete the evaluation. This is really helpful for our grant reporting. And if you want to receive a certificate, you have to complete the evaluation. Once you complete the evaluation, take a screenshot. So it's either going to look like, thank you for taking the survey. So screenshot that. Then if you forget to take a screenshot and you go back to the page, it's going to say, you've already taken the survey. So you can screenshot that as well. And just send it to me and we will have our intern create some certificates and she'll send them out as soon as she can. Another disclaimer, I am not a lawyer and could not give you any legal advice during today's training. So I'm going to go back to this page so that you have my email. And please let me know if there are any final questions or any questions I didn't get to.